Good morning. It's Tuesday, May the 6th. The session, who knows what day it is. I'm Mary Tips, Executive Director of Texans for Lawsuit Reform. Welcome to TLR Tuesday. With me today is Lee Parsley, our President and General Counsel.
Hello, Mary.
Hey, we got, less than a month to go.
I know. Well, yeah, less than a month. It's almost over.
Almost to the second. We're going to make it successfully.
I'm hopeful we're going to make it with at least 3 bills on the governor's desk, and we've got good progress we're making on those so far.
We are. And we're fortunate today to be joined by J.J. Isbell, founder of Texas Transeastern, celebrating its 42nd year in operation. Congratulations. He founded the company. It's a fuel-based hauler in 1983 with faith, family, and hard work as the company's rock-solid foundation. You had 2 trucks and a handful of employees, and now you're in 6 states with 550 employees? That's amazing.
Just north of that, yep.
In the early days, it said you were doing everything you could to keep it going and make it successful. Tell us today how that environment is for you, working for you.
You know, I'd say the biggest change over these 40 years is just the legal environment. I mean, where I would used to spend majority of my time working with our employees and working with our customers with our business, I spend over 50% of my time now dealing with legal and lawsuit issues.
Well, that's kind of an incredible thing to have to say, but give us a flavor of that. Why is it you're spending 50% of your time dealing with lawsuits? Just
the environment has changed. You know, used to, let's just say we were involved in a minor fender bender, it would be, hey, we're so sorry that we're involved in this incident with you. We'll fix your car. You'll get you a rent car. We'll cover your wages for a couple of days while you're having to deal with this. To now, the first call that those people make is to an attorney, and the first thing they do is send us attorney rep letter, and then the second thing they do is they send their client to a doctor that they're working with, and it just goes from there. And that minor incident that might have been $5,000, $6,000 now, they run up these costs, these meds, and these other things, and it's out of control. It's just made the whole environment upside down.
Yeah. So your experience was that it's the same accident, essentially, the same injury to the extent there was injury then and now, but the difference is the lawyer involvement, the fact that people are calling lawyers immediately, and then the lawyers become involved, and the whole thing spins out of control.
I'd say it's multi things. So these minor incidents where there isn't a true injury, they're calling attorneys because of all the billboards and all the advertising. They're calling attorneys, and these attorneys are sending their clients to these doctors who are doing these multiple MRIs and trying to find things or manufacture things that are alleging injury where this accident couldn't have caused an injury because it was so minor. They're running up these medical bills because these doctors are in collusion with the attorney. So what we're seeing in depositions now is the first call that the claimant made was to an attorney, and the attorney routed them to a doctor. So if somebody was hurt, if any of us were hurt in an incident, the first thing we're going to do is go see a doctor.
Right.
If we're hurt.
Right.
If we're not hurt, we don't need to see a doctor. Well, they're calling their attorney, and the attorney's routing them to a doctor so that they can get all these tests done, all these injections done, and just it's case after case. Every attorney has, I guess, gone to the conference or whatever it is to find out how to do this.
So how quickly typically are they calling the lawyer? Is that something that you're seeing where they do it, that afternoon or the next day kind of thing?
Yes, we are getting attorney rep letters as soon as the same day.
Oh my gosh.
Wow.
So the advertisement's working because all the lawyer ads I see are essentially, we're open 7 days a week, 24 hours a day. Call us first. Don't call your insurance company. Don't call anyone else. Call us first. And it sounds like those ads are working.
Well, it sounds like
call centers. They're running call centers. So they run these call centers to take these calls and route them. I don't know if the call centers are owned by an individual attorney or if it's groups that pay these call centers. But these call centers not only taking calls, but these call centers are also calling, which we know is illegal, but they're also calling and soliciting these claimants.
Well, this is fascinating to me to have somebody that's on the ground dealing with this. The attorney rep letter you say you get as soon as the same day as the accident. Is it just don't shred files, or are they already demanding $10 million? What does the letter look like?
No, it's a form letter just saying that this individual that we were involved in an incident with is being represented by, whatever attorney, and that all communication has to go through them.
And then what? How does it go from there? What happens next?
The next step is you get served with a lawsuit, and alleging all this negligence, and that's happening. So just to put it in perspective, 80% of the incidents we're involved in are not our fault, but we still get sued.
It doesn't matter, does it?
No, we still get sued for every one of them because trucking companies are an easy mark because they know we carry high limits of insurance. So we get sued on every one of them. So we get the letter, and the next thing we get is served with a lawsuit, which costs thousands and thousands of dollars to defend, even if we didn't do anything wrong.
So I've seen some of the lawsuits. I don't see the demand letters very often or the representation letters very often, but I've seen some of the lawsuits, and they come in pretty soon after the accident, it looks like, and they all seem to allege negligent training, negligent supervision, negligent hiring. And it seems to me they could not possibly know what your training regime was or your supervision regime is, 4 days after the accident. How can they draft a lawsuit that accuses you of negligent training when they have no idea what amount of training the drivers had?
I think it's the old shotgun approach. They just shoot out there and see what'll stick.
So is it just a form petition? They're giving you the same petition every time?
Yes, pretty much. They just change the name and the dates. I mean, they figured out the game, and that's what they always do. If we're able to get our bill passed, they're gonna figure out another angle for another industry or somebody else. That's what they do. But they've definitely figured out the angle on attacking the any Texan that operates a vehicle in Texas is a target.
Can you, JJ, give us some examples of some of these lawsuits you've been served with?
Absolutely. So one, just to show the amount of fraud involved in the medical side. So we have a case that we recently settled. It was involving 3 plaintiffs in a vehicle that actually ran into the back of our trailer on the side, but it was in a bad venue. So we were trying to get it settled. They had $480,000 in meds that they had run up. Of course, they were all incurred, none paid. $480,000 in meds.
Okay, can I interrupt right there?
Yes.
Did you feel like those meds were legitimate? I mean, in terms of the medical billing?
Absolutely not. So what we're seeing is, and that's why this SB 30 is so important, is what we see is things that would cost $500. Let's say an MRI. If Blue Cross Blue Shield or Aetna paid for that MRI, it'd probably be in the $500 range. But what we're seeing is they'll charge as much as $8,000 for an MRI and put somebody through 5 or 10 of those MRIs just to run the numbers up, so that they have a negotiating point. So back to this case. So keep in mind, $480,000 in meds, 3 plaintiffs. That case settled for $100,000. So let's analyze the math on that. So if the lawyer gets $40,000, 40% right off the top, plus expenses, you have 3 plaintiffs and all those medical providers splitting $60,000. How is that possible?
Right.
It's not possible.
No.
It's because the meds aren't real. We have another case that's still pending. In the deposition, now they've run up over $100,000 in meds for this one plaintiff. And we were asking her about the doctor, and she said, I haven't seen the doctor. And I was like, hang on a second. Your lawyer submitted all these bills showing that you had all these treatments done. And she said, I work. I haven't been to a doctor.
Whoa.
So we're talking about fraud, and we're talking about corruption. This bill that we're fighting for is not taking the right of any Texan to be restored or to be made whole from damages. It doesn't hamper anybody's ability to be taken care of. It just takes the fraud and corruption out of the system, because that's what we're dealing with every day.
Right. And that's a great point, JJ, and I'm glad you went there. Is that, we're always in tort reform. I've said this before on this podcast. We're always in tort reform trying to draw the line between legitimate and illegitimate. And it's not always an easy line to draw.
Right.
But we have no interest, not at TLR, not you, JJ Isbell, running a company, in preventing people who are legitimately injured from getting what they deserve in terms of payment for their damages and full payment for their damages. What
Absolutely.
we care about is the crooked deals, as you say, the fraud. And that's what we're trying to do in Senate Bill 30. We're just trying to differentiate between the just made up medicals, complete, absolute fraud on the system, and people who are legitimately injured.
And if this bill passes, those who are legitimately injured will get to court faster because it's not clogged up with all of these frivolous suits.
Exactly.
Absolutely. Good point. Very good point. It's just, and we're having to fight uphill because, of all the things being said. But I keep emphasizing that to the folks I'm talking to, that this bill doesn't cap anything. This bill doesn't limit your damages, for your legitimate damages. If you get hurt and you go to the doctor, actually, we've actually added more, 300%. Not just what the cost, 300% of what the cost is. So there's still room in there, but we're just trying to have a baseline, something that we have that we can say, hey, this person had knee surgery. Aetna would pay $35,000 for that. Blue Cross would pay $32,000 for that. Medicare would pay $28,000 for that. At least we have a baseline,
right,
to go from. Not a knee surgery's $800,000, and that's what we're dealing with today. And these jurors, they don't know what medical costs. They have no idea. They go, they say 800, they say 50,000. I guess we just split the middle. We'll give them 400,000. They don't know. And it's just a way to level the playing field because it's not level today.
right.
This is as good as Texas is. Our system's corrupt when it comes to this lawsuit, this personal injury lawsuit abuse. It's out of control.
So let me jump in there just so our viewers understand that 300% of Medicare metric that you talked about. The bill will provide that if a doctor, hospital, chiropractor, whomever it is, files an affidavit in the process that their reasonable medical bills were at 300% of Medicare or less, in other words, 3 times the amount Medicare would have paid for those services or less, then that provider is done with the lawsuit. They have established the reasonableness of their charges. The bill says those are going to be deemed to be reasonable. And that provider doesn't have to give testimony at trial, doesn't have to participate in the lawsuit. So therefore, legitimate providers can treat people who are injured in accidents. They can then file the affidavit, they're done with the lawsuit, and they can go on and treat the next person and the next person and the next person. They just get to practice medicine like we want them to do. And they establish their charges. They get 3 times the Medicare reimbursement rate just because that's then deemed reasonable. And that is a great solution, I think, for this. 3 times the Medicare reimbursement rate is, since Medicare pays for a lot of medicine in Texas, it's a pretty good outcome for those providers to be able to provide that affidavit and move on. The providers who are kind of cheating the system, are they going to participate? I don't know. But if they don't, they'll have to go sit on a witness stand and try to justify $850,000 for a knee surgery. And that's the goal here is you file your affidavit and continue to be a legitimate healthcare practitioner, or you go to sit in front of a jury and try to defend your overbilling. And I think that's a pretty good place for us to be.
That's a good point, Lee. And I think we need to really make sure people understand that. I think this will make healthcare more available for those that are injured.
Absolutely.
Because what legitimate doctor is going to treat somebody and do surgery on their back or their knee or their neck and wait 5 years to get paid for that? That's just that's not normal. And what legitimate provider would do that?
Right.
And if we say, hey, because Aetna and the Blue Crosses of the world, they're getting about 150% they're paying about 150% of Medicare. That's
right.
About the normal deal. So if a provider can get double that by treating somebody, what provider wouldn't do that and get paid fast? Get paid faster than a 5-year lawsuit.
Right.
But if you're willing to wait 5 years to get paid, obviously you're part of the problem, not the solution.
True.
You're right about that.
Okay, I have a question because I'm not being an attorney or this. JJ, in the case that you settled for $100,000, you've got $40,000 that goes right off the top to the attorneys, and then the $60,000 left over that's owed for medical. What went to the plaintiff? Anything?
We don't know. And another thing on that, and just so you know that the attorneys are directing everything, that attorney settled that without getting any input from the medical or his plaintiffs. So the attorneys are directing the whole thing. But that's my point. So the plaintiffs, the 3, and the medical providers had to split 60,000. I have no idea how they split it.
Oh, got it. Thank you.
But still, it just shows how messed up the system is, that they're willing to take $100,000 when they know they got $500,000 in medicals.
Doesn't sound like it's the best interest of his client.
No, absolutely not. And it's not just 40,000. That's the part of the game too. That's what I love about the personal injury guys when they say, "Oh, we're in it for the injured victim." Well, why don't you do it for 10%?
Right.
Right.
You know, if you're in it for the injured victim, you wouldn't be taking 40 off the top plus expenses. Now, if they went through depositions and had to hire court reporters, that's expenses. If they had to hire experts, that's expenses. That's on top of their 40%.
Yeah.
So, you know, the claimant is probably, if no medical's involved, is probably only getting 25, 30% in the best case scenario.
That doesn't seem right to me.
No,
Well,
the whole system's messed up.
It is messed up. So
So
we're going to take a bite out of that this session. Senate Bill 30, I think, is going to level things out. I hope it does. I've got confidence in that when we put some rules of the road, so to speak, into the litigation system, some new rules of the road, I think we're going to stabilize the litigation environment in Texas. It'll be harder for courts to ignore the law. I think we'll have to comply with what we write down in the statute books. And then the next consequence of that, I hope, is to stabilize the insurance market in Texas. And we get the insurance market in Texas, and insurers will stop leaving and will start coming back to the state, I hope. That, I hope, creates competition in the insurance market, and therefore it is to be dreamed, at least, that insurance rates at least level out. And if going down wouldn't be bad. And then, of course, the cost of insurance costs you money. You have to pass that on to your consumers, which gets passed on to the ultimate consumer. This is all paid by me and you and everyone else listening to this podcast, ultimately. And so the ultimate result of Senate Bill 30, I hope, is that we do our little part to curb the increased cost of goods and services in Texas.
Agreed. We do have a model. You know, when the state fixed the workers' comp model, that was eat up with litigation. When that got fixed, you know, we can hope that auto insurance rates go down because of this. I firmly believe they will. But we have a model. When we got the litigation issue fixed in workers' comp, and workers are better taken care of today if they're injured than they were then. We fixed that and got the litigation out of that, and Texas has some of the lowest workers' comp rates in the nation.
Yeah.
Of all the states we do business in, Texas has the lowest workers' comp rates.
Well, another good example, the medical liability. Doctors and hospitals, we did medical liability reform in 2003. Doctors and hospitals' insurance rates went down for their malpractice insurance.
Yep.
And we saw pretty immediately doctors coming back to Texas to practice medicine, hospitals expanding their services, which is good for the ultimate consumer again. Who benefited from that ultimately? We expanded access to care in Texas for more people in more places because of tort reform. And it's a provable fact. And so
Agreed.
I hope we have that same outcome with Senate Bill 30. That's my dream.
Yeah, this is a crucial time. I mean, it is a crucial bill that really has a chance of fixing a really, really out of control problem.
Well, we thank you for being with us today and for agreeing to come tomorrow and to camp out with us in the JCJ committee till who knows what time. It's a wrap. Thank you, everyone. Mary Tips, Lee Parsley, JJ Isbell. Have a great day, and we'll see you tomorrow.
Thank you.